In today's segment of Ignorance is No Defense, we are going to be talking about the criminal justice process. And my name is Desiree Cochran Norfolk, and I am an addiction counselor. I have a master's in addiction counseling, and I am certified by the Georgia Addiction Counselors Association as a certified clinical supervisor, a certified master addiction counselor, and a CAC2. I am certified by NADAC as an SAP, and I also hold a certified anger management facilitator certification and a family violence intervention program facilitation. So we can think of some stupid laws that we already know of, like not eating chicken with a fork on Sundays. And it's illegal to keep a donkey in a bathtub. This one's funny, but oddly, there is a reason behind this one. In 1924, an Arizona farmer allowed his donkey to sleep in an old bathtub. A dam burst and then the town flooded, and the donkey, who was still in the bathtub, floated downstream. He was rescued, of course, but the ordeal took a lot of man hours and manpower, and after that, several states passed laws against keeping donkeys in bathtubs. You can't live on a boat for more than 30 days during the calendar year, even if you're just passing through the state. No one can carry an ice cream cone in their back pocket if it's on Sunday. This one's another weird one, but it does have a source. Horse thieves apparently used to put ice cream cones in their back pocket to lure horses away, and is probably related to horses being tied up during church. In Ackworth, all citizens must own a rake. Obviously, this one was passed in jest, but it's still on the books. Kennesaw, a nearby city, passed a law in 1982 declaring that all citizens had to own a gun. So Ackworth retaliated, saying that all their citizens need a rake. In Athens, Clarke County, adult bookstores may not sell alcohol. Also in Athens, Clarke County, if you want to read your favorite book in public to your friends, you need to do it before 2:45 a.m. This probably has a lot to do with drunk college students. Owners of mules may not allow their animals to roam around Athens, Clarke County unsupervised. Persons under the age of 16 may not play pinball after 11 p.m. in Athens, Clarke County. Just pinball. Pac-Man's fine, but pinball, that's no-no. It's illegal to make a disturbing sound at a fair in Athens, Clarke County, and it's also illegal to honk at any fair in the state, so don't honk your horn. If you're going out of business in Athens, Clarke County, you have to have a separate business license to hold a going out of business sale. Also in Athens, Clarke County, it is illegal to sell 2 beers for the price of 1. And while Georgia runs its own lottery, it is illegal to promote a private lottery, and this is done under the guise that the government is protecting their citizens. If an organization is not registered as a nonprofit but does not register their raffle with the local sheriff, that group risks paying up to $10,000 in fines and spending 5 years in jail. So don't hold a raffle if you're not a nonprofit. And if you do, register it with the sheriff first. Members of the state assembly cannot be ticketed for speeding while the state assembly is in session. So J. Tom Morgan, he used to be the district attorney for DeKalb County, one of the metro area counties in the state of Georgia. And he wrote this book called Ignorance is No Defense. And he wrote it for teenagers who were getting into trouble because they didn't know it was against the law to do certain things. And what I've found in my many years of doing counseling in the field of addiction is that most people don't know what the laws are. Unfortunately, most people, even though they've been through the criminal justice system, don't understand the criminal justice system. And a lot of people don't understand the difference between a misdemeanor and a felony. And it's really just the amount of time. A lot of people want to say, oh, it's the severity of the crime. It's actually both, but according to the law, it's just the amount of time served. So for a misdemeanor, you're typically going to serve less than a year in jail, and a felony is anything over a year, and it's typically served in prison. Now, you may start out in jail until you get sentenced, and you have to wait until the prison comes to get you, but then you'll serve the rest of your sentence in prison. So the first court hearing that you go to after you are arrested, and most people think it's your arraignment, which is way, way later in the process. It's your first appearance. You have to have this, I believe, within 48 hours. This is just a formal reading of the charges against you. Some people just don't understand what they were arrested for, and the judge needs to make sure that the person knows what they were arrested for. You are not pleading guilty or not guilty here. Then, after that, comes the preliminary hearing. And this is where a prosecutor has to show enough evidence exists to charge the defendant. So preliminary hearings are not always required, and the defendant can choose to waive the preliminary hearing. It has to be held within 14 days of that initial appearance if you're being held in jail, but if you're not, then it has to be held within 21 days of that initial appearance. And it's kind of like a mini trial. So the prosecution, they call witnesses, introduce evidence, and some of the evidence that is allowed to be presented here at the preliminary hearing might not be allowed to be shown at to a jury at trial. And if the judge then concludes that there is probable cause to believe that a crime was committed by the defendant, a magistrate judge will then bind it over to a higher court, like a superior court. If the judge doesn't believe that the evidence establishes probable cause, then the defendant committed the offense, they then dismiss the charges. Most of the magistrate judges are going to bind it over because they don't want that on their hands. They leave it up to the superior court judges. So the probable cause here, a lot of people don't understand the difference between reasonable suspicion and probable cause, or they don't even understand what probable cause is. It just means that a reasonable person would believe that the crime was in the process of being committed, or it had been committed, or it was going to be committed. So if you're standing on the street corner looking around suspicious, that may not be probable cause. But if a car alarm is going off and you're running away from the car, that could be probable cause. If I see somebody running away from a car and a car alarm is going off, I could reasonably assume that they were trying to break into that car. So probable cause is enough for a search or an arrest warrant. It is also enough for a police officer to make an arrest if he sees the crime being committed. Reasonable suspicion, on the other hand, is a little bit less. So the U.S. Supreme Court has defined reasonable suspicion as the sort of common sense conclusion about human behavior upon which practical people are entitled to rely. And then it defined it further as requiring only something more than an unarticulated hunch. So you can't just say, I had a feeling. You have to be able to articulate it. It requires facts or circumstances that give rise to more than just bare or imaginary or just purely conjectural suspicion. So you can't just be like, gut feeling here. You have to have a fact or circumstance that common sense would tell you that a crime was committed, or it was in the process of being committed, or was going to be committed very soon. So if an officer has reasonable suspicion in a situation, they can frisk or detain the suspect briefly. Reasonable suspicion does not allow for the searching of a person or a vehicle unless the person happens to be on school property. Reasonable suspicion is not enough for an arrest warrant or a search warrant. A lot of people confuse and misuse reasonable suspicion and probable cause. Both of them have to do with the officer's overall impression of the situation, and they have different repercussions on the person's rights, the proper protocol, and the outcome of the situation. So reasonable suspicion is just this step before probable cause. So at the point of reasonable suspicion, it appears that a crime may have been committed. And then the situation escalates to probable cause when it becomes obvious that the crime most likely has been committed. So stop and frisk. Terry v. Ohio in 1968, the court recognized that a limited stop and frisk of a person could be conducted without a warrant based on less than probable cause. So if they have a reasonable suspicion, they can stop you and frisk you. The stop has to be based on a reasonable, individualized suspicion based on articulable facts. And the frisk is just limited to a pat down for weapons. So an anonymous tip that a person's carrying a gun is not in and of itself sufficient to justify a stop and frisk. In Florida v. Bostic in 1991, a person's refusal to cooperate is not sufficient for reasonable suspicion. In Illinois v. Wardlow in 2000, a person's flight in a high crime area where after seeing the police was sufficient for reasonable suspicion to stop and frisk. So the same requirement of founded suspicion for a person stop applies to an to the person's vehicle. In United States v. Arvizu in 2002, the scope of the frisk for weapons during a vehicle stop may include areas of the vehicle in which a weapon may be placed or hidden. In Michigan v. Long in 1983, the police may order passengers and the driver of or into the vehicle pending completion of the stop. In Maryland v. Wilson in 1997, the passengers may not be detained longer than it takes the driver to receive his citation. And once the driver is ready to leave, the passengers must be permitted to go as well. So during a stop for traffic violations, the officers need not independently have reasonable suspicion that criminal activity is afoot to justify frisking passengers. But they do have to have reason to believe that the passengers are armed and dangerous. And that's from Arizona v. Johnson in 2009. Party to the crime law. This is specific to Georgia. Other states have different versions of this, but this is a clause in the Georgia law. And it states every person concerned in the commission of a crime is a party thereto, and they may be charged with and convicted of commission of the crime. So what this means is if you have anything to do to further the act of a crime, then you will be charged with that crime. You will be convicted of that crime, and you can be sentenced to the maximum of that crime. So if you drive somebody to a bank and they rob the bank, then even though you didn't rob the bank, you can still be charged with bank robbery. If you supply somebody with a gun and they go and shoot someone, then you can be party to that crime. And if they killed that person, then you are then culpable for that death. And then even if that person who killed the other person gets, a 20-year sentence or a life sentence, you could still be on the hook for the maximum punishment for that crime. And it could potentially be the death penalty. And that happened in the Kelly Gissendaner case. She didn't actively kill her husband, but she asked her boyfriend to. And she was ultimately sentenced to the death penalty, whereas the actual person who killed her husband received life in prison. So this is only if you directly commit the crime or if you indirectly cause some other person to commit a crime under such circumstances that the other person is not guilty of any crime, either in fact or because of legal incapacity, or if you intentionally aid or abet in the commission of a crime, or if you intentionally advise, encourage, hire, counsel, or procure another person to commit a crime. I met this young man one time, and he was on pretrial probation for eating a slice of pizza. He said he was actually in there for armed robbery. Apparently, he was at a party, and someone robbed the pizza man at gunpoint, and everybody at the party ate the pizza. And because they ate the pizza to get rid of the evidence, they were all charged with armed robbery. So this is how petty this can get. So after the preliminary hearing, most people are like, arraignment. No, it's not the arraignment. It's the bond hearing. Now, this is for felony cases. Most misdemeanor charges already have a set bond, and you can bond out almost immediately after you are booked into the jail. But for felony cases, you have to have a hearing where the prosecutor can ask for a high bond amount or no bond or whatever bond they want for you. and the judge is going to hear your side as well as the state's arguments, and they're going to make a decision about your bond. So then comes the grand jury, and most people are confused on how many people sit on a grand jury, and everybody says 12. No, it's not 12. The answer is actually 23, and sometimes there's 2 or 3 alternates. So that's a lot of people. So at a grand jury hearing, the grand jury is listening to the prosecutor, they're listening to the witnesses, and then they're voting in secret. They're not deliberating with each other. They're voting in secret on whether they believe that enough evidence exists to charge the person with a crime. They're not voting on whether they think you're guilty. They're voting on whether there's enough evidence to charge you. So a grand jury may decide not to charge someone based upon the evidence. And if that happens, a no bill would occur or no indictment would come from that grand jury. You are not allowed to attend a grand jury hearing against you, and the prosecutor can present whatever evidence and witnesses that they want to. So this is typically where the prosecutor has done what we call charge stacking. This is where them and all of the interns in their office and the paralegals, they are poring over the law books and they are finding whatever laws that you could have possibly broken, and they're going to put everything out there, including lesser charges, hoping that something sticks against you. So you may have been initially charged with just one charge, but when your case comes out of the grand jury, it could come out with 5 or 10 new charges, sometimes more. And these new charges are now called indictments. So now we get to arraignment. And this is just another formal reading of the charges against you. And they have to do this after the grand jury indictments because now they have to read you the new charges. Just like at that first appearance, they have to make sure you understand what you're being charged with. So the reason why you couldn't plead guilty or not guilty up to this point was because whatever you were initially charged with isn't necessarily what you're going to be charged with at the grand jury. So the judge is going to read these new charges to you, and it is at this point that you can now plead guilty or not guilty. And this is typically when the prosecutor will come with some sort of deal for you. So if you plead not guilty, you're going to undoubtedly be faced with a series of visits to the court called calendar calls or status conferences. I call them dummy missions, where you just show up and then disappear and then come back again in a couple months. When the judge is going to ask you and your attorney and the state's prosecutor if they are ready for trial. So if they are not ready, they're going to ask for a continuance to the next calendar. Or if there's not enough time on the court's usual 6-week calendar to get to your case, then the case gets continued to the next calendar. And for the metro area, it's different than some of the rural areas, but this is typically 8 weeks away. So they have 6 weeks on, 2 weeks off, 6 weeks on, 2 weeks off. And the courts are just so backed up with cases. It's also a tactic that the prosecutors use to get people to plead guilty to a lesser charge, because your case can sit there for 2-3 years waiting and just keep having to come back for calendar calls or status up conferences. And if you have not pled guilty by the time that a judge gets to your case and both sides are ready, you will go to trial. And if you're convicted, you will be sentenced by a judge, and you can get up to the maximum amount of time for whatever charges that you were found guilty of. And the state's going to usually use this opportunity to ask for the maximum sentence as a punishment or retaliation towards you for making them take you to trial when you knew you were guilty the entire time. Some people are confused on what a split sentence is. This is just a sentence where the defendant serves up to half of their term of imprisonment outside of prison. So it's typically called probation. And probation is only given out by a judge at sentencing. You can't go back and get probation later. You can get a sentence modification maybe later on, but it can only be given out by a judge. So if you ever hear like the term 10 do 2 or 20 do 5 or 20 do 10, that is what we call a split sentence, because the sentence is like, let's say a 10 do 2. you're getting a 10-year sentence, but you're only having to do 2 of it inside the prison. And then the rest of the 8 are going to be served out in the community on probation. Parole is when a person who's sentenced to prison, they serve a majority of their time in the prison, and then they're released from prison a little bit early for good behavior. But they're monitored by a parole officer for the remainder of their sentence. And in Georgia, there's a whole chart on this, on when people can get out on parole based upon the severity of their charges and what level. So I think it goes to like 8 or 9 levels. But level 8 or level 9, whichever is the highest, those are the bad ones, like the 7 deadlies. And I think you have to do something like 90 or 95% of your time before you can get out